first, let's take a quick break and listen to our friends over at 4patriots.com while we rehydrate our mouths and do not become parchment paper. My friends, a food shortage could be coming. Even in the United States, experts have written about this as recently as July. Drought, inflation, even new policies are pushing America's food supply near its breaking point. That's why survival food is more important now than ever. And you can create your own stockpile of the best-selling 4Patriot survival food kits ever. This is not ordinary food. We're talking about good for 25 years super survival food, hand-packed right in family-owned facilities in the United States, giving jobs to over 200 Americans. The kits are compact, they're sturdy, they're water-resistant, and they stack easily. They have different delicious breakfast, lunches, and dinners, and you can make these meals in less than 20 minutes. Just add boiling water, simmer, and serve. And right now, you can go to 4patriots.com. Use code Robert to get 10% off your first purchase on anything in the store, including this 3-month survival kit. You'll get their famous guarantee for an entire year after your order, plus free shipping on orders over $97. They're called 4Patriots because a portion of every sale is donated to charities who support our veterans and their families. Go to 4patriots.com. Use code Robert to get 10% off. That's 4patriots.com. Use code Robert. Start building your own stockpile today. Yes, that's right, my friends. Go on over there to 4patriots.com. Great company, and we appreciate them for supporting the work that we do here. But now let's get right back into it because we have 3 more top lists to get to. And we're going to start by going to California and listening to this guy, Gavin Newsom, who looks very confused in this GIF. The top 5 crazy California laws. It's a crazy state. They're doing a lot of crazy things. And unfortunately, they are spreading around the country. Arizona is getting all of their leftovers. Rain voters were turning blue. It's gross. They're also Californicating all the rest of America. And so what's happening there? And are we going to see Gavin Newsom run for president? Is some of this stuff coming to the rest of the world? Let's see what they are up to. Several radical laws going into effect this year. This article comes from Joel Pollack over at Breitbart. The title is called California's Crazy New Year, 5 radical laws that go into effect. Only one is on hold. We have the 5 most radical laws plus one currently on hold. The first is SB 107. This one is raising a lot of eyebrows. The Sanctuary State for Transgender Kids Law. This law, signed by Governor Gavin Newsom, protects the use of drugs or surgery to provide so-called gender-affirming care to children from other states where the use of those treatments is restricted or criminalized. It prohibits doctors from releasing information to other states, and it prohibits California courts from interfering in child custody over such treatments. Here's the text of the bill. You can see it's quite long. Passed in September. The U.S. Constitution requires a state generally to give full faith and credit to public acts. Existing law authorizes the extradition of a person and so on. This bill would prohibit a provider of health care from releasing information outside of the state. This bill would prohibit the enforcement of an order based on another state's law authorizing a child to be removed from the state. So, for example, if you had one parent who was in Texas and another parent who took a child out of Texas and took them to California and wanted that child to go through transition procedures or, whatever the process is there, and Texas said, no, you can't do that, bring that kid back here, they would not honor it. And so the U.S. Constitution, as they even admit here, it generally requires a state to give full faith and credit to other states of every other state. But they're not going to do that here. This came out from Scott Wiener. He writes a lot of these bills. The law will be amended to be changed as follows. Talking about amending for subpoenas, civil procedure is amended. So it's a pretty hefty bill. It's sort of defining a bunch of things. It's going through civil code. It's going to family code now. Here's what it says for family code. A court of this state that has jurisdiction to make child custody determinations may decline to exercise its jurisdiction if it determines it is an inconvenient forum. Okay. Big, big bill. Lots to go through. That's now in effect. This is the story from the father who's actually going through this. This came over from ChristianPost.com. Texas Supreme Court rules against the father seeking to prevent the, quote, chemical castration of his son. Here's a picture of father and son. A Texas father has accused the Texas Supreme Court of being a party to child abuse. The person's name is Jeff Younger, gained national attention for his opposition to his ex-wife efforts to identify their son, James, as a girl named Luna. He went on Twitter on Friday at the end of 2022 and said, "The Supreme Court of Texas denied my mandamus, effectively terminating my parental rights. My children are now subject to being castrated in California chemically." He says, "Texas is an empire of child abuse led by Texas judges." The justices wrote in their denial, this is in the petition, it looks like, in the denial, "In the matter involving Jeff Younger out of the Supreme Court of Texas, Justice Blacklock writes, denying the petition for a writ of mandamus." This is the father of the son arguing, asking the court to do something. This case arises from a child custody dispute involving twin boys, one of whom, they say, has exhibited confusion about his gender. Mother, who has custody of the boys, recently moved to California after a Dallas County District Court in September authorized the mother to reside with children anywhere in the country. Texas said in Dallas County, you can leave. Father, the relator in this court, so the person who's related to the child, is concerned that mother's move to California will bring about the medical, quote, transitioning of his son. 3 months after the district court authorized the move to California, father belatedly seeks an emergency order from this court requiring their return. The judge says, "I concur in the court's denial of the petition because father is already in possession of a court order prohibiting mother from doing precisely what he fears she will do with his son." Oh. In October, the district court, with the mother's full agreement and indeed at her request, ordered that neither parent may treat a child with hormonal suppression therapy, puberty blockers, and or transition without consent of the parents or court order. This agreed order is binding on both parents and enforceable by contempt, no matter where they reside. The effect of the order is that neither parent has the legal authority to consent unilaterally to gender transition therapy, whether that therapy takes place in California, Texas, or elsewhere. As long as this order is in effect, mother's parental rights do not include the right to obtain therapy, gender transition therapy for her son. That is just as much the case in California as it is in Texas. Well, we don't know. We don't know about that now. Okay, so this is the question now. This may have been true when this got published on December 30th, but what now about January 1? If the mother decided to do it, okay, the understanding is that from the new California law, it is a sanctuary state. It prohibits doctors from releasing information to other states and prohibits California courts from interfering in child custody over such treatments. It says that it protects the use of drugs or surgery where the use of other treatments is restricted or criminalized. Okay, so I guess the question here is whether or not the mother is going to adhere to this rule adhere to this. Mother freely acknowledges that she is bound by this order in both Texas and California. So if mom says, I'll adhere to that, mother has flatly denied to this court that she'll seek to evade this thing while she's in California. Should she fail to honor her promise, contempt of this court's order would not be her only concern. Father believes that California enactment of the bill will enable mother to evade the Texas court order. But father misreads California's new law. The judge says, by my reading, father's fears are no more likely to be realized than they would be before the bill. The judge says, described by its lead author as a trans refuge bill designed in part to respond to executive and legislative action in Texas, footnote 1, This is from Scott Wiener. He wrote that in a press release. Okay, so he's like actively campaigning for this. He says it is going to be a refuge for trans kids and their families. Come to California. It's going to be a safe place for you. Like if you're like, bring your kid from away from dad, kind of a thing, right? So, but the judge says, yeah, he did call it a trans refuge bill. And the bill certainly does cast a wide net in pursuit of its objective. The bill contains several provisions barring enforcement in California of, quote, a law of another state or another state's law that prohibits that gender-affirming care. Thus, says the judge, SB 107, this bill, as advertised and as written, is California's response to other states' legislative enactments and rules outlawing gender transition therapy. All right, so California, they're great with transition therapy. Texas, not so much. While SB 107's position on other states' laws is clear, he says, I see no provision in the bill that would alter the enforceability of a Texas court order requiring divorced parents to agree to therapy. So he doesn't see anything in that bill. Now, as we just read through, right? Obviously, we didn't read through the full bill. This is the full bill here. And it's big, which means there's a lot of gray area in there. Looks like a lot of new stuff. All these amendments, okay? Amended to read. So, right, I don't know if they're inserting this in the bill or just modifying. In Arizona, when we have these things, they'll give you sort of what looks like a change record, a change log, right, on these bills. So they'll strike out stuff that got deleted. They'll put the new stuff in blue. Old stuff is out in red. So I don't know what is actually being inserted or changed, but it's a pretty big bill there. The judge says, Father reads the bill's prohibitions on enforcement of another state law against gender therapy as a prohibition on enforcement. It is not. A court order allocating the parental rights of divorced parents based on case-specific findings is in no way a law of another state. Okay, so he's saying that the judge is distinguishing between a court order and a law of another state. California is responding to laws of another state. He's saying that court orders, yeah, this is the unconstitutional part of this, where the judge is saying, look, in the very unlikely event that California courts interpreted their statute in such an odd way, they would, of course, run headlong into the full faith and credit clause. Okay, so the Texas courts are referring us back over to the U.S. Constitution, and they say, hey, the Constitution says you can't do that. But my friends in Texas, California doesn't give a crap about the U.S. Constitution. Are you nuts? They don't care about that at all. And they'll do whatever they want. So, okay. So, all right. That's nice that he thinks that they'll abide by that. We'll see. The bill's authors were likely aware of the prevailing interpretation of the full faith and credit clause, under which states have some leeway to deny enforcement of other state laws, but little to deny other judgments. We'll see. U.S. Supreme Court decision supports roving public policy about judgments, right? One state judgment gets full faith and credit in another state. We'll see. You know, the author of the bill literally, I think, is trying to do something kind of cutesy here. Sort of like what happened with some of the abortion laws, right? Trying to sort of manipulate things and bring this to a head. We'll see if it does. Yeah, the judge acknowledges this. This is fun. Understanding this important distinction, evident throughout the text of the bill, between another state's law, there's a quote, between another state's law, he says, while SB 107 treads close to territory prohibited by the full faith and credit clause, very close, and ultimately may be found to transgress it in various ways, nowhere does the bill purport to prevent enforcement of California out-of-state child custody orders establishing which parents may consent to gender transition therapy. This is wild. So this judge is acknowledging this law is like, it may actually transgress the full faith and credit clause. He says it right here. May ultimately be found to violate it in various ways, but not in the way that dad is complaining about right now. And then if you rewind this, it's just like, and we have faith that the California courts are going to give full faith and credit to our judgments. It's like just, delusional, honestly. It's like, are you crazy? They're not going to do that. They wrote the bill for this. They wrote the bill to push up against this this potential constitutional limitation. So the judges say, okay, to summarize, under an existing Texas court order that mother agreed to and that mother acknowledges is binding on her. So that's the safety valve. But if mom decides, well, we're just going to go get some treatment, and she goes into California, she goes into a clinic, I don't think she's going to, she's not going to have to report it out. And if the clinic just says, yeah, this is California law, then I'm not sure he can do anything about it. He'd have to file something there, and then the California courts would have to step in and address it. But Texas is putting a lot of faith in the California courts, faith that I don't have. Mother lacks the legal right to consent to gender transition therapy for her son, says the court. This legal disability is just as real in California as it is in Texas, and mother readily acknowledges this as well. When a custody order specifies that joint parental consent is required, then a California doctor, just like a Texas doctor, must ensure that the appropriate parents have consented to treatment administered to their children. Footnote 2, this is a California Superior Court case from 2008. Again, before the law went into effect, before all of that law went into effect. Under the district court's order, any doctor in any state giving gender transition therapy would have to talk to the father and get consent. They say nothing in the law changes that. Father's concern is that California court could undermine the Texas order at the mother's request. He points to a different provision of the law, says that because the child has been unable to obtain these things, that the state could act under emergency jurisdiction. The court says no. To obtain that emergency order, there would still be safeguards. Mother would have to take the position that there's an existing order that's an emergency threat. Mother has repeatedly asserted that the Texas order is desirable and in the child's best interests. Mother would have to claim a very severe, dire emergency. California court would then have to say it is an emergency and then take an extraordinarily unusual step of issuing an emergency order. Judge basically says, no, this is too tenuous. The speculation here is about what other courts might do in the future. The only court to have acted so far here has preserved the father's right to have a say in gender transition therapy. The right is enforceable in California. He says that might raise, there might be another case where this pops up, but that is not this case. Right. And I think the judge is right about this. So either this case will turn into a case that is an issue. Like if the mother just decides to switch, this now suddenly will become a case. If California just does something a little bit questionable, this will become a case. But right now it's all kind of quiet. The judge is like, well, the wife's not saying anything about this. And technically I don't see a way for her to do it. If she does, if California interprets it differently, which I think is, sort of a high likelihood because it's not Texas, then the judge is saying, come back again at a later time, then it will be ripe. But it's not now. Interesting. I didn't realize there was a full opinion on that, so I'm glad we just kind of came across that kind of accidentally as we did. But that is a very interesting new law that will be signed into effect in California. We also have AB 2098. Number 2 in the list of California's craziest laws. This is the new COVID misinformation law. This law, signed into law in September, requires California's medical licensing boards to take disciplinary action against doctors who are involved with the dissemination of misinformation related to the pandemic. The law does not take into account the fact that authorities like Anthony Fauci have changed their recommendation over time. Yeah, and I read more about this, right? The law requires your licensing board to take disciplinary actions if you disseminate misinformation. Okay, so if you get on Twitter, you're a California doctor, and you say something that goes against the CDC and somebody reports you for mis or disinformation, the licensing board has to take action against that person. This is, it's an absolute attack on free speech. That's crazy. But Evidently, that's what they're doing. Let's take a quick look. Actually, I think that's linking us to the same stuff. Okay, so we'll move on. They're also decriminalizing jaywalking in California because of racism. Freedom to Walk Act. It says that jaywalking is a racist crime because it's enforced unevenly. All right, so you can walk all across the streets in California now. It's going to be a free-for-all. Drive carefully. SB 1375 in California. This one allows nurses to perform abortions without doctors. Great. This law attempts to expand access to abortion by allowing qualified nurses to perform certain abortion procedures in the first trimester. This new law will take effect alongside a new provision in California's constitution, passed by a referendum, guaranteeing the right to abortion and contraception. Yeah, I mean, eventually, California, you can probably I don't know, Uberize abortions and probably drive-throughs, and they'll come to you, they just come right to your place. Just Uber it, star ratings and whatever. All right. So number 5, decriminalizing loitering for prostitution. Another Scott Wiener law. He comes from San Francisco. Very interesting fella. Decriminalizes loitering in public for prostitution. That's still a crime. But the loitering part, they want to take care of that part. That's also a crime. They want to remove that. Also allows for those convicted of loitering to petition courts for dismissal. The law aims to remove the social stigma of sex workers. Comes across at a time where there's a statewide crime wave. So that's what's going on in California. Now, as we talked about, right, there's a lot of conspiracy theories out there about stuff that might happen in 2023. We talked all about that with real Ben Sellers. And if you think it's crazy, it's not really that crazy because much of it is happening in California as we speak. We'll, of course, continue to cover it. Thank you for subscribing and joining us as we do.